This over here I found on the Ombudsperson, BC Ombudsperson's Office, British Columbia Ombudsperson's Office annual report. So over here, someone got discriminated. It doesn't state the nationality or exact circumstances of this case, but it could be both of these parents. They could be Chinese citizens who went to Canada to have a baby, or both of these parents could be like Mexican or whatever. Who knows? Could be anything. But based on the information over here, there's two foreign. It appears that there's two foreign parents who are not Canadian citizens and not permanent residents of Canada, but the children are entitled to education, public education in Canada. So they're probably Canadian citizens by birth, the children, and the parents are two foreigners. So they got discriminated by School Board 23. So that's like in Kelowna, Okanagan District. And so they're using this ordinary resident thing to discriminate against people. So the school board, Kelowna School Board District or Okanagan School District, which is 23, says that students a student is a resident in British Columbia if the student and the guardian of the student are ordinary residents in British Columbia. So this goes back to common law again. And then it goes on to say, while the Act does not define the term ordinary resident, the ministry states that in the policy that boards of education must determine in a fair and even-handed manner whether the applicant falls within the common law meaning of ordinary resident. So ordinary resident is a common law term. It has a common law meaning determined by previous case laws. So to be an ordinary resident of a place, your stay has to be legal. Second, it has to be voluntary. It has to be voluntary. You have to be voluntarily in the place. You cannot be imprisoned or have your rights taken away because because you're being imprisoned or detained. And the second is that the third requirement is that it's for settled purpose, long and short duration. So it doesn't matter if you plan on staying or if you are staying for a short or long duration. If it's for settled purpose, such as not being a tourist or a visitor, you are an ordinary resident. So who are government bureaucrats, whether they be school districts or the Insurance Corporation of BC, who manages driver's licensing to determine if somebody is an ordinary resident or not? Government officials or bureaucrats or employees do not have the right to determine who is an ordinary resident of British Columbia or whatever place in a common law jurisdiction. Common law has a common law meaning set by previous court cases by a judge. People do not cease to be an ordinary resident due to temporary absence. And ordinary resident means a different thing from domicile, habitual resident, or actual resident. So there are these laws for a good reason. You cannot be providing education for someone from like a different province, but people from a different province could be coming to BC to settle because people have mobility rights protected by the Canadian Charter of Rights and Freedoms and also protected by the UN Declaration on Human Rights that Canada has signed and ratified. So government workers who are racist and don't like Chinese people, Mexicans, or brown people, whatever, would take out these random archaic laws and hope that people do not understand common law, don't know what ordinary resident means, and they would create a twisted and deranged interpretation in order to screw people, in order to create a hostile environment policy to make life as difficult, hard, and miserable as possible with the hopes that people will leave.